by Charles Cumulou. The decision of the Court of Appeal sitting in Abuja to send the Senate President, Senator Bukola Saraki, back to the Code of Conduct Tribunal, CCT, to answer to 3 counts of false assets declaration, has set the stage for another round of high-wire politics in the polity. This observation is so fitting that even those who may consider it as questioning the judgment of a court of competent jurisdiction, would not help but concur. A retrospection on the history of the case and its effect on the polity in the early period of this administration, leaves no one in doubt that the stakes have been raised once again by the court's decision. An evaluation of the grounds upon which the court said the Senate President has a case to answer, perhaps, leaves more questions than answers regarding the latest situation. A 3-man panel led by Justice Teyodakomo Wilson gave the ruling last Tuesday, saying the Economic and Financial Crimes Commission, EFCC, had done enough to prove the 3 charges it referred back to the CCT. Interestingly, the court agreed with the CCT that on 15 counts of the 18 charges filed against Drive Bukola Saraki, it was proved beyond reasonable doubt that the evidence were based on hearsay that lack probate value. Notably, it averred, like the CCT, that the information used in putting together the charges against Saraki by the federal government, did not connect Saraki with the charges as demanded by law. It further held that the federal government erroneously came to the conclusion that the onus to prove the 15 charges was on the defendant, whereas it is established fact that the party that alleges must be the one to prove beyond reasonable doubt. With these, the judgment seems to have literally punctured allegations of operating foreign account, collecting double salaries, anticipatory declaration, and failure to declare assets owned by companies in which he has shares. The fact that the aforementioned allegations formed the fulcrum of all the claims against the Senate President, presents the argument that their dismissal by the court could as well have served as an acquittal of the entire issue. Specifically, the educated thinking in some quarters is that, having identified the flaws of the federal government, the need by the court to have saved 3 of the counts may not have been particularly compelling. Those who argue in that regard point at counts 4, 5 and 6, which the Court of Appeal referred back to the CCT for Saraki to enter its defense, stating that the appellate court probably, may have, in its invaluable wisdom, chosen to embark on a voyage of discovery. In expounding the argument, the controversial House 17A and 17B, which formed the basis of counts 4 and 5, is one and the same. Count 5, which is on non-declaration of a loan which formed the source of funds for the purchase of the property cited in counts 4 and 5, were also relevant. Instructively, the court referred the counts back for trial in the belief that the prosecution established discrepancies in the claims on the asset declaration forms as to how the 2 houses located in Ikoyi were acquired. The judge said the Senate President needs to explain the discrepancies, that the properties he claimed to have bought with proceeds from sale of rice and sugar in his asset declaration form were actually bought from loans acquired from a commercial bank.